Hello, everyone. Thank you so much for joining us today for our presentation, Dental Practice Transitions, Understanding the Process of Buying or Selling a Practice. I'm Kelly Bach with ProSites, and if you're not already familiar with us, we develop customizable practice websites as well as marketing and efficiency software to make running and growing your practice as easy and streamlined as possible. Today, I'm very excited to be joined by Levi Barlavi, dental attorney and president of the Pacific Health Law Group for this presentation. Levi is a top trusted attorney with over a decade of success in assisting healthcare professionals just like you. And today, he's going to walk us through all of the legal implications you need to be aware of when it comes to buying or selling your dental practice. Before we get started, just a few housekeeping items. We'll be sending out the recording and handouts to all registrants after the webinar. So if you have to hop off early or if you have a colleague who wasn't able to attend live, you'll still have access to all of the information afterwards. Also, after the webinar, a quick survey will pop up on your screen. We would greatly appreciate if you took just a moment to fill it out. Let us know how we did, what you thought of the presentation, and what you'd like to see from us in the future. And lastly, if you do have any questions, feel free to submit them through the chat, and a member of our team will reach out to you to follow up after the webinar. So without further ado, thank you so much for joining us today, and I'll hand it over to Levi.
Thank you, Kelly. Appreciate that. Welcome everyone to this webinar. We're going to go over the ins and outs of dental practice transitions and try to give you guys some valuable information if you're headed towards that journey for yourself in buying or selling a dental practice. First, a little bit about me. I grew up in Los Angeles and I graduated from UCLA and Georgetown Law School. I started my practice around 2010, and the nucleus of my practice took shape a few years later, and I've been working almost exclusively with healthcare professionals, mostly dentists in all sorts of practice settings for the last 10 years. And I represent dentists in practice startups, acquisitions, and sales and mergers, and regulatory compliance matters. I speak regularly at events. It's always nice to do in person. It's a little bit strange to do on the webinar, but I'm glad you guys are joining and look forward to presenting for you. So first, let's talk about a little bit why are we here today to discuss practice transitions. Basically, what I always tell my clients is that going through a practice transition can be a really anxious experience if you're on the buyer side of the deal. It can be the first time you do a major acquisition, and it can be pretty stressful. And on the seller side, it can be very emotional because you're either retiring or you're moving or you've spent many years in a practice. And so the 60 or 90 days you're involved in this transition can be really stressful. So what I like to tell my clients is, if you know the basics about the journey that you're going to go on, it's going to relieve some of that stress and allow you to focus on some of the critical things that you have to accomplish along the way. So we're going to learn the basics about your future dental practice sale, the transition process, mistakes to avoid, and answer any of your questions. So the process is more familiar to you and less stressful when you're in the middle of it. And the reason is because making avoidable mistakes can be costly. In addition to understanding the basics, we can reduce your anxiety for a better transition. So first, let's talk about the practice sales process. This slide that I'm about to jump into is what I usually go over with my clients, either on the sales side or the buyer side, before we even enter into transitions. It's the first consultation we discuss about the process. This is a 10-step process to buying or selling a dental practice, and it really starts with the seller's journey. Typically, what the seller will do is hire a practice broker, a business broker who specializes in selling dental practices, and they'll hire the right broker. The right broker is one who is very familiar with the local environment, economic environment, has a good feel for the prices in the market, can properly appraise the practice to set it to sale to market, and has the marketing arm to properly market the practice to potential buyers. Buyers, so once that happens and the broker packages the practice, they market on their website, they market through newsletters and different trade associations and trade magazines, and then the buyers will find the practice and start putting offers on them. If you are a buyer side, you want to get on as many listings for the practice brokers in your area to get listings routinely once you're starting to look. There's no universal MLS like in the housing market where you can go and find all the practices in your area. These are all listings by different brokers. So you want to get as many listings as possible and as many newsletters as possible to get those listings. Once a buyer finds a practice that they like, they usually put in an offer via deposit or letter of intent. And that offer, if the price is right for the seller, is accepted by the seller. And then that starts the process of the buyer's due diligence and loan approval. Due diligence is just another word for the opportunity of the buyer to look at the practice financials, profit and loss statements, tax returns, take a look at the patient charts and do an audit, look at the different systems and software that the seller is using, maybe bring in someone to check out the equipment to see if it's operational, to get an understanding that this that the offer that they put in is matched by what's going on actually in the practice. The buyer at the same time is getting a loan approval. Almost all dental practice sales are 100% financed by bank loans. And so there's specialty banks in the market who will provide you financing and have a very good underwriting system for these practices. And this is a good point to know, is that because most buyers have to 100% finance their loan with the bank, the brokers generally understand the market and will price it against those loans, knowing that the associate doctors who are in the market to buy a practice are going to go have to get underwriting from these banks to get 100% financing. And so usually the prices that sellers have the practices at are around the market price of what a buyer can expect to get a loan approval for that practice. So it's not a appraisal process if you get the loan, meaning that the price is the correct value, but it is a good barometer if you get the loan to determine whether the price of the practice was priced to market. After the due diligence and loan approval process, the parties then negotiate the major transaction documents. Most of the time, about 99% of the time, the buyer is going to buy the assets of the seller's practice and move those assets into the buyer's corporation or set up a corporation to own the practice. Included with the transition documents can be an employment agreement for the seller if the seller is going to stay on after the sale. Perhaps if you're not going to get 100% financing from the bank and the seller's amenable to it, the transaction documents can also include a seller carryback note where the seller loans part of the purchase price to the buyer. The next component of the transition is that the buyer has to get approved by the landlord, the premises landlord, for a lease or a lease assignment. This is critical. You can't have a dental practice without a lease. Most practice sales do not include the purchase of the building. Most sellers don't own the building, and even when they do, they're not necessarily selling the building with the practice. If they're not, the buyer has to review the seller's lease with an attorney, determine if there's anything onerous or problematic with the lease, apply with the landlord to get approved for as a tenant for the building. And then the lease, depending on where the seller is with their lease, if they have years remaining or a few months remaining, the lease will either get transferred over to the buyer in the form of a lease assignment, or the buyer might get a new lease at that time if there's not a lot of time left on the seller's lease. It's important when you're reviewing the lease to make sure that with your attorney what your lending conditions are, so that the lease is transferred to you and the seller's attorney can transfer it to you. Your attorney can help transfer it to you so that your lending conditions are met. After all of those documents are finalized, generally the documents are then signed. There's a few days between signing and closing, and so there's some pre-closing obligations that have to be fulfilled, including the seller maintaining the practice in the normal course, the buyer meeting certain conditions to closing. Then there's a closing, but that doesn't end the relationship of the buyer and seller. Even if the seller does not stay in the practice after the closing, there's some post-closing obligations the parties have to take care of during this process. That includes how are accounts receivable handled, what happens if there's problematic treatment that arises that the seller performed, how do we handle retreatment cases, and how is uncompleted treatment handled? What if the seller was in the middle of finishing up treatment but didn't finish up before the closing? All of those obligations are going to be part of the purchase agreement and the transaction documents that the attorneys are going to help the doctors negotiate, and will lay out the framework for how those things, post-closing obligations, are handled after the closing. So that's a general sense of the process. It generally takes about 60 to 90 days from the point that the offer is accepted in step 3 to get to step 9, the closing, and do all of those intermediary tasks. So it's really important, I think, that every buyer and seller get just a basic understanding of what is involved in the letter of intent. The letter of intent outlines the key features of the transition. So it outlines the major deal points. What is the purchase price? What assets are included? What are not included? Generally, the practice includes all of the assets of the practice except for personal items, cash, accounts receivable. The LOI sets what kind of restrictive covenants, sometimes called covenants not to compete, that the seller is going to be obligated to after the sale. Even in states, for instance, like California, where covenants not to compete are not enforceable, there are exceptions in the sale of a business whereby the buyer can restrict the seller of that business, when they're buying the business's goodwill, from working in an area for a number of years. In Southern California, that's generally 3 to 5 years and 10 to 15 miles. In other states, there might be different restrictions that a buyer can perform in the agreement to restrict the seller. The LOI also gives a timeline of the transaction. Over here, I said 30. Over here, I have 30 to 60 days. That was generally pre-COVID. After COVID, things have seemed to slow down a little bit. Banks are taking a little bit more time to do their underwriting for loans. And so the sweet spot is about 30 to 90 days. The general transaction timeline is 30 to 90 days, with the sweet spot being about 45 to 60 days. And for almost all LOIs, there's usually an earnest money deposit that's included. That's generally 1% of the purchase price. So if it's a $750,000 practice sale, you're generally putting in $7,000, $7,500 into escrow account as an earnest money good faith deposit, which will be credited against the purchase price. So another thing that's critical to LOIs to understand is that there's non-binding and there's binding versions of LOIs. Most LOIs are non-binding, meaning the agreement that you've come to in this document, no one is bound to it until they've actually signed the purchase agreement. It is a guideline. However, parts of the LOI can be binding, specifically regarding the deposit and if it is forfeited if the buyer doesn't close or close within a certain amount of time. And not all LOIs are created equal. Some are very short and others are very long. Typically, the shorter the LOI, the quicker the parties are able to get involved in the deal and move the process forward. But potentially, the shorter the LOI, the more missing material deal points that are left to be negotiated later that might slow down the transaction. If the LOI is longer and includes more information, more deal points, it might be harder to get the deal off the ground because so much is being negotiated on the front end of the deal. But the benefit of that is that if you've negotiated a lot of the hairy stuff, the hard, difficult deal points in the beginning, it leaves a much clearer runway to get through the transaction. So not all LOIs are created equal, and there's benefits to having it arranged in different ways. So once you get past the LOI process and once you've done your due diligence and you've gotten your loan approval, generally the parties are then going to negotiate an asset sales agreement. Sometimes they call the asset purchase agreement, sometimes called the buy-sell agreement. This is the major contract that is going to outline all of the obligations the parties have to each other before, during, and after the sale, and also what is included in the transaction. So I'm going to give you an overview of some of the general things that are included and what the parties have to think about when reviewing their document. So what are the key features of an asset sales agreement? First of all, it talks about what assets are being sold. Almost everything is being sold except the personal items, vanity websites, cash on hand, accounts receivable, maybe claims that the seller has to refunds or deposits, maybe their personal digital accounts, Spotify, some things that they use in the office. An asset sale agreement is going to transfer all of the assets from the seller's practice to the buyer's practice. Because the assets are being sold, then the parties have an opportunity to allocate the purchase price among these different asset classes. So there's goodwill that's being sold, that's one of the assets. There's equipment, furniture, fixtures, and equipment. There's patient records, there's supplies and consumables. All of these get different prices based on what the purchase price of the practice is. And these allocations have a significant effect, especially for the seller. For the seller, how these assets are allocated determine what type of tax is paid by the seller. For the amount of the purchase price that is allocated towards goodwill, the seller is going to pay significantly less tax on that because that is considered capital gains tax. It's 15%. For the assets, the purchase price amount that's allocated to equipment, the seller is going to pay ordinary income tax, usually around 30% or more. For the buyer side, these allocations determine the amount and length of depreciation that the buyer has with the new assets that are being purchased. So for goodwill, usually a buyer will depreciate that over 15 years. And for equipment, the buyer will depreciate that over a shorter time frame. Restrictive covenants. When a buyer comes to buy a practice, it is essential to protect that investment, to restrict the seller's ability to compete with the business that they just sold. While some states do not allow restrictive covenants, almost all states permit such covenants in the sale of a business, so they are enforceable. In California, a lot of sellers think because they've heard that restrictive covenants are not enforceable in California, that they can sign any contract, it won't be enforceable. And I've seen doctors get into trouble with this, not knowing the rules that restrictive covenants are enforceable in these type of business sales. So generally in Southern California, it's 10 to 15 miles for 5 years. This is different. Once you get into more rural areas, the covenant can be longer, but the mileage is generally the same, 3 to 5 years. In addition to this restrictive covenant, the seller also might have restrictions on seeing patients or soliciting employees or vendors or contractors from the practice. It's extremely important for the seller to understand what they're signing and to understand this before they move into a transaction, especially if the seller is not retiring, is young, has plans in the future, or owns any other practices in the area. It's important for a selling doctor to talk to their attorney to explain potentially the other practices that they own, where they're located, if there's key employees that they move from one practice to another, and to minimize the impact of these restrictive covenants so that the seller can continue to practice how they want to practice after the closing. And also for the buyer side, it's important to map out, and understand what the seller's plans are post-closing to add proper restrictions in there to protect the buyer's practice. One of the most important things that I do for my clients in these agreements is handle the representation section in the purchase agreement. Representations are truthful assertions about the state of the practice. These are facts related to staff issues, state of the equipment, state of the seller's financials, records, any potential legal issues. There's two ways of doing due diligence for buyers. One is they do due diligence in person. They get financial information from the seller. They give it to their CPA. They might bring in an equipment consultant to check out the equipment. They might bring in a practice consultant to check out the practice systems. That's one way of doing due diligence. Another way of due diligence is the legal side, and that's what your attorney works on. From a buyer's side, we want to make these representations that the seller's making in the agreement as broad as possible so that we suss out any information that we may not have learned doing the in-person due diligence. From the seller side, we want to make sure that we're mitigating the risk of misrepresenting something so that the seller's not sued after the closing for stating something in the contract that is not accurate. And this is a very, very important point. There's a lot of brokers out there who will just present what they call form purchase agreements to the parties. And especially for the seller, if they don't read this or understand what they're representing, they can be open themselves off to risk of a lawsuit. And from the buyer's end, if they don't properly expand the number of representations in there to suss out information, they might be buying a practice that has issues that they didn't pay attention to during the transaction process. Okay, so a practice is a organic business. There's a lot of moving parts in the practice, and so there's some things that we have to handle and outline in terms of what happens after the closing. For instance, if the seller has patient credit balances, how are these handled? These are overpayments that patients have made where there's refunds that need to be paid to the patients or third-party financing company. How are those refunds handled? The seller either has to refund those all at the closing to those patients. Sometimes those credits are then transferred over to the buyer, and now the buyer has taken on that liability and has to honor those balances with patients. And so The purchase agreement will outline how these points are handled to mitigate any problems that the parties face during the transition because they didn't understand this. Uncompleted treatment, who performs it and how do they get paid? The seller might have started some treatment before the closing that they are not able to finish before the closing. For instance, if they're, they have a crown that they've temporized the tooth and they're waiting for the lab product to come back and it's going to come back after the closing, how is that handled? Almost always, we want the seller to finish his or her treatment and get paid for that. We don't want the buyer and the seller to perform treatment on the same tooth and then have a liability issue if something goes wrong. So seller performs the treatment in the practice, not in another practice, in the practice after the closing, and it gets paid for that, but has to reimburse the buyer for use of maybe the buyer's chairside assistance or supplies, and definitely the lab product. Also, we might have patients who come into the practice after the sale who have retreatment issues, who complain about the work that the seller has done. How are these handled? The buyer should not handle this retreatment. They should notify the seller of the retreatment. The seller should warranty their own work, and the seller should then agree to perform that treatment in the practice, retreatment in the practice of the sale. If the buyer performs a retreatment without notifying the seller, the buyer should then not be able to tell the seller that the seller owes them money. So we want to make sure that the contract carefully outlines how these issues are handled so that the parties are not confused and then disputes arise between the seller and the buyer after the closing. Accounts receivable. Generally, accounts receivable are not part of the practice sale. So the seller is selling the practice cash-free and debt-free. So there's no liens moving on over to the buyer, but the buyer is also not taking any of the seller's cash or accounts receivable. If the seller sells the accounts receivable to the buyer, that is a separate price that is usually paid for the AR. In almost all instances, the seller does not sell the AR to the buyer. And so we have to determine how it's collected. Usually the buyer, who is now the employer of the staff, will collect the seller's AR for a certain amount of time, 4 to 6 months after the sale. So why do we have the buyers collect the seller's AR? Because there has been instances where sellers who are no longer owners of the practice after the sale will aggressively collect the AR and therefore ruin the goodwill with those patients who have never met the buyer before because they haven't come in for their recall yet. So the purchase agreement should outline how accounts receivable and how these kind of continuing obligations are handled after the sale to minimize the potential disputes between the parties. So what are the key features of a well-drafted purchase agreement? So it has nuanced provisions like we talked about related to dental practice sales. I cannot handle I'm a business attorney, but I don't handle transactions for instance, other types of business sales. Although I understand the language, I deal with those nuances in these type of healthcare related deals. And so good purchase agreements will usually have experienced attorneys in that industry that know how to add these nuanced provisions to help the parties when any type of dispute. A good purchase agreement will minimize and mitigate for risk. So your attorney should protect your investment if they're the buyer and should protect the seller for any potential ongoing liabilities post-closing. That's my number one job when I tell my clients is when you're buying a dental practice, you're making a huge investment, a huge monetary investment, a huge career investment. It's my job to mitigate the risk in that investment. And for the seller side, it's my job to help you realize all of the hard work, cash out the equity, but let you sleep well at night by minimizing the risk that you have made a mistake in the purchase agreement and opened yourself up to liability. And then competent drafting, good use of clear, precise language that makes it easier to read between the parties and avoid future disputes. So now we'll talk about some common mistakes and obstacles that the parties make in the transaction, and as we look to wrap up this presentation. So one common mistake is the unprepared seller. Don't go it alone. So unprepared sellers don't hire a broker or hire the right broker. A lot of sellers want to sell the practice on their own, and the difficulty of doing so is that if you have plans on retiring or moving, you may assume that you're just going to get a buyer and it's going to be a smooth transaction. But if you have one buyer in front of you, you are subject to that buyer's whims. And if they take their time in the deal, you can get incredibly frustrated. So not hiring a broker sometimes is a big issue for sellers in terms of the timing of the transaction and when they want to sell. If you have an associate working in your practice and you want to sell it to your associate, that lends itself to a very smooth transaction where you might not need a broker. And then another problem is sellers who don't hire the right broker. The broker who will properly appraise the practice, who has very good marketing and knows how to market the practice to sale, knows the economic factors in that area, and also will be involved in the transaction the entire time and not just leave you once you find a buyer and not have your questions answered. An unprepared seller doesn't have well-prepared and ready financials. You will need, as a seller, 3 years of profit and loss statements and tax returns completed before you get into the sale. It's going to help you appraise the practice better, and it's going to help the buyer get their due diligence and loan approval done faster if all of those documents are ready. An unprepared seller doesn't have a copy of the lease documents and amendments. Many sellers have been in their space for many years and may have amended the lease 2 or 3 or 4 times. If there's missing amendments or missing lease documents and the seller can't provide the entirety of their lease documents to the buyer's counsel, it's just going to slow the process down. So a prepared seller should have all of their critical documents, including the lease documents and tax returns and financials, ready before they go into the sale. An unprepared seller is one who doesn't notify their accountant and their financial planner for proper tax planning purposes. How much can you expect to get from the sale after you paid your consultant and broker? How much you're going to have to pay for taxes, and how do you treat these allocations in the purchase? These are all questions that the seller should answer before they get involved in the deal to make a much more smoother process. And then finally, a seller who doesn't hire an attorney, hires an attorney very late in the process or hires the wrong attorney. I've had many doctors over the years who've come to me and said, I have a buyer who we're going to close in 1 week. Can you look at this purchase agreement? Unfortunately, I usually cannot do that, and it doesn't leave your attorney with enough time to help you and mitigate all of the risks that we discussed during the process. So you're going to want to hire an attorney once you're ready to put your practice up on market, or once you got an offer, accepted offer, not later in that 60 to 90 day period, in the beginning of the process. And you're going to want to hire a dental specific attorney, someone who understands the nuances of dental practice transitions. Don't just hire your cousin Sal, who's a personal injury attorney, or someone who doesn't understand these things, because there's a lot at risk in selling a practice if you don't understand these nuances. And the same factors work for the buyer. The unprepared buyer, do not wait until the right time to start your search. It can take a very long time to find the right practice that you want. And so I always recommend to my buyer clients or when I give presentations is, if you have a plan of buying a practice in a year from now, even if you don't think you're ready right now, put yourself on all the broker lists, start looking at all of the listings out there to get an understanding of what's out there. Start contacting a bank, start contacting an attorney, and get your team ready so that you can hit the ground running in when you're ready to sell your practice. So here's something that I find that buyers really run into when looking for a practice. They don't have the vision down. What kind of practice do you want and where? Buyers who want like the perfect practice will never find it, because you are essentially buying someone else's practice that they've started in their vision. And so what you want to do is have an understanding of what you want out of practice. Is it location? Is it a type of practice, high-end PPO? Is it, volume-based practice, cosmetic? What type of demographics? You should have a good understanding of these issues. If you can hit 75%, 80% of the things that you want from a practice in a practice you find on the market, that's a fantastic find. But if you're looking for the perfect practice that checks all of your boxes, you're unlikely to find that practice, and you're going to delay your opportunity to become a practice owner and start making money and changing a practice to the way you like it. Similar to a seller, a buyer who doesn't hire an attorney or hires an attorney late in the process or the wrong attorney, you want to make sure that if you're going to invest $1 million into practice, $500,000, $750,000, you have adequate counsel that is going to mitigate the risk of this investment and protect you in the documents. And a buyer who doesn't hire a good consultant, CPA to help them with the due diligence process. Almost all of us who went to graduate school, dental school, or law school, or any other graduate school, we're not prepared to handle business terms usually. And so it's very helpful for you to walk through the financials of a practice with a CPA or a consultant who's going to tell you that, yes, this is a good deal, or this practice has some red flags associated with it, and determine whether it's a good investment for you. You have to look at the process of buying a practice as an investment, not just an ability for you to do the type of work that you want to do. And then, the last thing is buyers who get caught up in very, very, very small details and don't see the big picture. I see this a lot in my transitions, and this is usually motivated or a symptom of a buyer who has a lot of fear associated with this process. So, you want to make sure if you're buying $1 million practice, you're not fighting over the seller with the seller in terms of who is going to pay the $500 cost of sending out letters of announcement. I have seen buyers ruin deals because of this without understanding that the real investment is $1 million practice. Usually when you see buyers get mixed up in these kind of details, it's a symptom of fear. So there's a fear factor associated with buying a practice, and that's understandable. It's a very large investment. It's a very large event in your life. You might have kids that are being born, you might be getting married, you might be buying a house at the same time. And so there's a lot of stress involved in this time period. Talk to your family, get mentally ready for the process to make sure that you're making clear decisions with your team. And also just talk to your team about what, any hangups you have, and they're going to help you along the way. I appreciate you guys for listening to this short webinar about practice transitions. Again, my name is Levi Barlavi. I'm a dental attorney. I've listed my contact information here. You guys are welcome to reach out to me via email or call the office if you have any additional questions. And thank you so much for your time.
Thank you, Levy. That was great. Like he said, for everyone with us today, Levy's information is on screen. It's also in the deck if you haven't already downloaded it. So if you'd like to get in touch with him afterwards to talk about any questions you have or to book a consultation, feel free to reach out or let us know in the survey after the webinar that you'd like to get in touch with him. And now just a quick note about ProSites. Practice marketing and buying or selling your practice really do go hand in hand. So whether you're acquiring a practice or are getting ready to sell your practice and want to get everything set up to ensure that you're getting the biggest return on your investment, ProSites can help you build an online presence that will help set you up for success in reaching those goals. If you'd like to learn more about how we can help, let us know in the survey after the webinar and we'll reach out to you to talk more. All right, folks, we want to be respectful of your time. So again, we will be sending out the recording and handouts in the next 24 hours. If you submitted a question, we'll follow up with you directly after the webinar. And lastly, don't forget to fill out that short survey that's going to pop up on your screen to let us know how we did. Thank you to everyone for joining us today. We hope you learned a lot and we look forward to seeing you at a future webinar. Bye.